House Bill 208. Please read it into the record.
Thank you, Madam Vice Chair. Members, this is House Bill 208 by Chairwoman Villio. It provides relative to eligibility for parole or diminution of sentence.
The chair's trying to work the water. Thank you.
You may proceed.
Thank you so much. Members, this bill, I have been working since the summer with probation and parole. It is simply a cleanup bill from the crime session parole bill. And it does three things specifically that I'll call your attention to. And it involves good time split sentencing and then eligibility for parole. And on the good time, it clarifies that good time eligibility for offenders who committed an offense before August 1. Keep in mind that that bill was effective and applies to only offenders and offenses committed on or after August 1 of 2024. There was some concern, however, that the way the bill was written, it put into question the fact that sex offenders and habitual offenders would not receive good time. They did not before that bill. They do not now. They do not when that bill was passed, and they're not eligible now. But we wanted to go ahead and make sure that was clear. So that's part of what this bill does, is just clarifying language. Relative to split sentences, if an offender receives a split sentence, they are required to serve their probationary period imposed upon release from incarceration. So remember, what the bill did was made the sentence 85% served, and then 15% would be good time. But that 15% would be unsupervised upon release. So what this clarifies, that if that original sentence was a split sentence, that they would not be unsupervised for 15% and then come serve their probation, because we all knew what would happen. A lot of offenders would not return for that probationary period. So this, again, is just clarifying language that the probationary period shall be served before that 15% of unsupervised parole. And then the last thing it does is it clarifies that relative to parole eligibility for those that are eligible for parole prior to August 1st, 2024, it changes the time period that an offender is to remain free from any major disciplinary offense from 12 months to 36 months, which we're doing that for consistency purposes with Act 11 that was passed in the crime session. That was Senator McMath's bill. And so we wanted to make sure that his bill, which became law, that language is clear within the bills that we passed relative to parole. And so that's essentially what the bill does. Again, it's clarifying language, cleanup language, and does not make any substantive changes to that which we passed in the crime session. Happy to take any questions and would appreciate your support.
Thank you, Madam Chair. Rep. Walters.
Thank you, Vice Chair.
Good morning.
Chair, good morning. Can you go back over the 36 consecutive months versus the 12 months and like why this is?
Sure. So if you remember with the crime session, one of the bills we passed was that for offenses committed on or after August 1, 2024, individuals are not eligible for parole unless they fall within the exceptions. Senator McMath passed a bill in that same crime session, which Governor Landry signed, and it's Act 11, which for anyone who is eligible for parole, and we're talking about those that fall within the exceptions for offenses committed on or after August 1, but also for anyone who is in prison prior to August 1. For those individuals who are eligible for parole, his bill and the new law requires that they be disciplinary free for 36 months. So we just wanted to make that clear.
Okay, and
So
why?
I'm not changing the law. That is
Okay.
the law through Act 11 from 2024. But we wanted to make it consistent within the statutes and the laws that we change within the parole bill that I passed to make sure that that's clear is all. It's not a new change. It's just clarifying again.
Okay, thank you. And also, staff, I've asked for a folder because I sat down and I'm having to use my laptop. Can I please have a folder? Thank you.
Thank you.
Rep. Horton.
Thank you, Ms. Vice Chair. Thank you, Chairwoman Villio, for bringing this. A lot of times when we have a session, a special session, and in the record time that we did it, you often have to bring legislation the following session when there may be some confusion when you make the changes that we made. So I appreciate this clarification. I know that our DAs and law enforcement will as well. So thank you for bringing it at the appropriate time. I'd like to move favorably.
Thank you. And Rep. Horton, to your point, I'd like to thank Probation and Parole, who worked extensively with me since the summer to work with me on what they thought was necessary, clarifying language for both consistency purposes and so that, offenders as well as the public and their own officers were clear on what to do. So thank you.
Thank you.
It looks like the board is now clear, Madam Chair. We have 3 red cards in opposition. Alex Moody of Lift, Louisiana, present and would not like to speak. Peyton Rose Michelle in opposition, present and would not like to speak. We have Chico Yancey, present and would like to speak.
Good morning, everyone. How you doing? We're opposed to this bill because, really don't understand adding 36 months to someone's time. And, this is going to cost a ton of money. Is the mic on? Can you hear me? Okay. You hear me now? Okay. First of all, thank you for allowing me to speak. We're opposed to this bill adding, more time, 36 months to be eligible. Also, is there a physical note on this bill? Anybody know? This is going to cost a ton of money. We're talking about saving money and everything, but we're adding, I know you're trying to change the language and straighten it up, but it's going to cost a lot of money. And our organization, and we talked to a bunch of people, we're really opposed to this bill. Thank you.
Thank you. And yes, there is a fiscal note on the bill. And Madam Chair, for your information, the original stack only had the red cards, so I'm moving in that direction to finish that out, and then we'll go back. I've got additional cards. Thank you. Up next.
Thank you.
You're welcome. Thank you for coming. Mary Ann Machat is present, would not like to speak, but opposes the bill. Next, we'll take up the green cards. In the order called, please report if you'd like to speak. Present and would not like to speak, but in support, Billy Joe Harrington, District Attorney, 10th Judicial District Court. Kevin Cobb is the Executive Director of Louisiana Sheriff's Association, in support and wishes not to speak. Gary Bennett, Louisiana Sheriff's Association, present, in support, does not wish to speak. Christine Russell, present, does not wish to speak. Bradley Bouget, I'm maybe being too French on you today, present and would not like to speak, but in support of. In support of, Zachary T. Daniels, Executive Director of Louisiana District Attorneys Association, in support of, does not wish to speak. Thank you. In the interim, here we go. Katie Hunter Lowry, red card, present and in opposition, but does not wish to speak. Present and will provide information, Jennifer Bush, Louisiana Division of Probation and Parole. And Rhett Carrington, Division of Probation and Parole, present and will provide information if necessary. Francis Abbott, Executive Director of the Board of Pardons and Parole, present and will provide information if requested. The board is clear. Madam Chair, you may close.
Thank you, Madam Vice Chair and members. And again, just to be clear, and I think I was sufficiently clear on the front end, but again, this bill does not change the law that was enacted in the crime session pursuant to Senator McMath's bill, Senate Bill 5, which is now Act 11, that an individual has to be free from major disciplinary offenses from 12 months to 36 months. That is the law. This particular bill just clarifies it in this portion of the statute, and I'd ask for your favorable passage.
Thank you. Representative Horton has moved favorably on the bill. Is there an objection? No objections. Thank you. That bill will be reported favorably.
Thank you, members.
Mr. Speaker and members, next bill in this order, House Bill 208 by Representative Villio, provides relative to release eligibility of incarcerated persons, provide for parole eligibility, automatic earning of good time credits for good behavior, compliance, credit elimination.
Chairman Billy, on your bill.
Thank you, Mr. Speaker. Members, this is intended to be a cleanup bill, but I do believe I have an amendment.
Madam Clerk, on the amendment.
We don't have. I think he's filing it right now.
Chairman Billy, can you go ahead and touch on your bill while we're waiting on the amendment?
Sure. Members, relative to the amendment, let me tell you a little bit about the amendment before it comes to the floor. I've been working with my colleagues who have had concerns about this bill. One of the substantive changes in HB 14 was that it eliminated what I considered to be street credit for probation. I am going to amend that out of the bill. So that substantive portion of the bill, which I had considered a cleanup bill, if you remember last year in the crime session, I talked about street credit. It was my intent at that time to include it in that bill. We discovered it had not been included. So I was going to do that, but in speaking to my colleagues with their concerns, we are going to amend that out. The rest of the bill has to do with technical violations. Act 8 of 2024 added that any violation...
Representative Villio, I apologize for interrupting, but I think your drafter has something to tell you.
No, we're not. We're on 208. That's okay. 208 or 214? 208. All right. All right, members. This is an interesting day. So apparently we're not even on 214, and I apologize, Mr. Speaker. So members, 208 involves the eligibility for parole or diminution of sentence. And this is a cleanup bill. And it does three specific things relative to good time, split sentences, and parole. Regarding good time, we had included in the legislation last year current law, with what was current law then, what is in the legislation from the crime session, and what is now. And that is there is no good time for sex offenders and no good time for habitual offenders. So this bill makes it clear that there is no good time for sex offenders and no good time for habitual offenders. Split sentences. An offender who receives a split sentence is required to serve the probationary period imposed upon release from incarceration. If an offender is released on unsupervised parole due to good time, which if you remember we put it at 85% with 15% unsupervised, we want that offender to serve their probation before they actually serve the unsupervised 15%, because we know what's going to happen. If they have no contact during that 15% of time, it's unlikely they're going to return to their probation officer and be successful and not recidivate. So all that does is clean up that language. And then the last thing it does is Senator McMath in the crime session had Senate Bill 5, which in order for a person to be eligible for parole, they have to be disciplinary free, major disciplinary free for 36 months. Prior to his bill And what the governor signed as Act 11 in the crime session, it was 12 months. It's now 36 months. So this bill, all it does, what happened is it wasn't clarified in the entirety of the statute. So all we do is make that clear within the statute. So I would propose to you members that this bill is simply a cleanup bill and a clarification bill, and I would ask for final passage.
Available with final passage of the bill. Those in favor vote yea. Those opposed vote nay. Madam Clerk, please vote machines. Members vote. Members vote your machines. Members vote your machines. DeWitt.
DeWitt, yea.
Jordan, yea. Nay. Jordan, nay. Speaker Pro Tem Mike Johnson, yea. Bacala, yea. Members, are you through voting? Members, are you voting? The clerk will close the machine. Jordan, I'm sorry, is now a yea. Now the clerk can close the machine. We have we have 90 yeas, 7 nays, and the bill finally passes. President Vilio moves to adopt title, which is both for final passage. A motion to table without objection, so order.
We're going to take Senator Vilio's bills.
I am a senator now. Thank you for the promotion.
Well, you get the same pay, put it that way. Well, Representative Vilio, and which bill do we want to start
We
with?
can start at the top if we want to go with 111.
Okay.
Good morning.
On your
Mr.
bill, Representative Vilio.
Thank you. Good morning, Mr. Chairman, members. House Bill 111, I actually worked with Senator Bass on this particular legislation, and it closes the loophole in our law that currently does not prohibit convicted sex offenders from attempting to lure children at school bus stops. And so this prohibits them within certain hours from loitering within 500 feet of children who are gathered for pickup or drop-off from the school bus.
Well, that is a loophole that sounds like it needs to be closed.
Absolutely.
The board is clear. We have 2 green cards in support. Kevin Hayes, Chief Police Association, not wishing to speak. Got some circus music going. And Scott Kirkpatrick, also with Chiefs of Police. In support, we got Gary Bennett, Louisiana Sheriff's Association in support, not wishing to speak. Kevin Cobb, Sheriff's Association in support, not wishing to speak. And Jennifer Ansardi, Jefferson Parish School Board in support, not wishing to speak. And lastly, we have a white card from Jennifer Bush with the Department of Corrections. Is present, will provide information as requested. No red card. Senator Cloud moves to report House Bill 111 favorably. Is there any objection? There being none, that bill will be reported favorably.
Thank you so much.
No, I'll do it. I'll do it in a bit. Okay,
House Bill 208.
208.
And I have my Chief of Police in Kenner with me, Chief Keith Conley, and Chris Walters from the Governor's Office.
Thank you, Representative Vilio, on your bill, House Bill 208.
Thank you. In its initial form, House Bill 208 is a parole cleanup bill from the crime session, and it essentially does 3 things. It clarifies the good time eligibility for offenders who committed an offense before August 1, 2024, related to sex offenses. Prior to the crime session, sex offenders were not permitted good time. After the crime session, they were not permitted good time within the legislation, but there was a separate statute that was repealed. So to clarify any confusion that may be caused, we went ahead and rectified that and clarified it within this bill such that sex offenders are not entitled to good time. It also, with regard to split sentences, as you know, we passed the law where offenders serve 85% of the time, and then they are on unsupervised parole for 15% of the time. We do not want sorry.
The board is clear. There are no.
I wasn't finished.
Oh,
I just
okay.
I wasn't sure if I should continue. The 15% of the time, we don't want them on a split sentence to go unsupervised for 15% of the time and then think they're going to actually show up to serve their probation. Chances are they will not, and that's not in their best interest, and it's certainly not in the public's best interest. So what we've done is mandated that on a split sentence, meaning that they have prison time plus probation time to serve, that they serve their probation before they actually serve out the 15% unsupervised parole. And then lastly, we made, if you remember, Senator McMath's bill, Senate Bill 5, which became Act 11 in the crime session, it requires that an individual be disciplinary free for 36 months in order to be eligible for parole. So we just made that consistent throughout the statutes. We found areas where it was still showing 12 months when it in fact is 36 months. So that is what House Bill 208 does in its original form, and I believe we have an amendment as well.
Okay, we have this amendment says 1927, Bill 208. Tell us what the exact
And I will go ahead and let Chris Walters with the Governor's Office and then Chief Keith Conley with the Police Department, Kenner Police Department, go ahead and talk a little bit about the amendment to 208, and hopefully one of the senators will offer it for adoption.
Okay, thank you. Go ahead.
Thank you, Madam Chairwoman Villio and Acting Chairman Abraham. Christopher Walters, Deputy Executive Counsel for Governor Jeff Landry. I think everyone is aware and was able to see Governor Landry's press releases on Thursday after meeting with the United States Immigration and Customs Enforcement leadership about Operation Go, as well as the executive order that we put out, Operation Go, to address illegal immigration in this state, and specifically with respect to illegal immigrants that are here that are caught up in the criminal justice system. This amendment that you have before you is something that other states have already done in the past. Specifically, we have heard from Michigan and seen in Virginia where they have a program similar to this. But what this amendment will do will be to establish a deportation eligibility hearing committee. So the way this will work in practice is that the Louisiana Department of Corrections has entered into 287G agreements with our federal ICE partners that will allow the Department of Corrections to exchange information with ICE officials, run offenders that are currently in the Department of Corrections through the immigration and enforcement databases to determine whether that individual who is in DOC custody is an illegal alien or is a foreign national that would require further investigation to determine their legal status at the time. So this deportation eligibility process has very narrow parameters to it at this time. So what would happen is that the Department of Corrections would get that information from ICE as to whether or not an individual has a final order of deportation or removal, or whether or not ICE believes that that individual should go through the process and has placed a detainer on that individual. And then it would only be effective as to individuals serving a DOC sentence that is not a sex offense and that is not a crime of violence with a sentence of 10 years or more. Once those individuals are identified, so they would have to have no qualifying offense, and either a final order of removal or a detainer from ICE indicating the potential for removal. That list of individuals will be sent to the governor and to the corresponding district attorney from whatever parish the conviction arose from. If consent is given by both the governor and the district attorney that prosecuted the case, that individual will then go to a deportation eligibility hearing committee, which would be made up of a 3-member panel of the current Committee on Parole. They would be able to hold a hearing, allow for any regular input as kind of like a regular parole hearing. If there are any victims or law enforcement or anyone else who wants to speak, they would be able to do that same way as any other parole hearing. And if the Deportation Eligibility Hearing Committee determined that that individual was appropriate for a release decision, that release decision would have to include the following requirements: that if they are released, that they are only released into ICE custody directly, that they are not released outside of the institution, but directly to ICE custody, that the remaining sentence that they would normally serve on parole within the state or wherever they're going to serve it, that remaining sentence is suspended upon the date of transfer from state custody to ICE custody, that the alien offender must remain outside the United States and the state of Louisiana upon removal, and that if that alien offender ever re-enters the United States and is found, that his parole will be immediately revoked and that he shall be remanded to state custody to serve out the remainder of that suspended sentence.
Are you all ready to answer questions?
We can, or
Sure. If the chief wants to.
Yeah, thank you for your time. Thank you for
certainly.
your support, law enforcement. I'm just here to support this.
State your name, please,
I'm sorry,
sir.
Chief Keith Conley with the Kenner Police Department.
Very good.
But I'm here to support this legislation. I commend the governor, Representative Villio, and this body for taking this on. This is a nice cleanup. In other words, these people are in custody of state and parish correctional facilities on taxpayers' dime. And this is very thorough. It has determined who could be allowed into this program for deportation. The victims, there's a notification process for the victims, for the prosecutors, for law enforcement. This amendment has everything in it that should satisfy anything involving due process, or certainly the relief that it would be have from having to house and give medical care to these illegal aliens, including the parole being suspended. And if they were to come back, they would have to immediately be returned back to that venue to serve out their sentence. So basically, Mr. Walters and Rep. Villio have given all the information, certainly more than I can give, but I'm here to show support. And, I am a member. Kenner is one of the two agencies that are part of the 287G program through HSI, and it's nice to be working with our federal partners trying to clean some of this stuff up. Kenner's got the highest population of Hispanics, and, they're the ones that are screaming for reform and screaming for help, the ones that are here lawfully, because they came here the right way, and they don't want these factions
Being
following.
terrorized by people who aren't here legally.
Absolutely. So, I thank you for your support.
Sure.
And he's here to support, we'll put him on the spot, his favorite legislator.
I don't know who that might be, but Senator Cloud is up for questions right now.
That's
Well,
right, could
I'd
be
like to
Senator.
be in the running for that title. Well, I guess the first question that I have, Mr. Walters, is: are there actually individuals in custody that fit the criteria for deportation under this, if this amendment passes and this becomes law?
Yes, so we are continuing to run the numbers as well as run information. That collaboration between the Department of Corrections and ICE is ongoing. It does take some time to get this information and run it through all the various databases that ICE has access to, but we are in the process of identifying those numbers, how many it would apply to, and then kind of move forward from there. I can tell you as of right now, we have identified something like 390 individuals in DOC custody that are potentially subject to ICE proceedings. Now that
They would go through the hearing. Yeah.
Not all of them, I believe not all of them have charges that would be eligible, because some of them, I think there's a decent portion that have life sentences, and then there's a decent portion that have crimes of violence that would be excluded from that. So
And
we're still working through those lists.
That was my next question. I see on page 1 of 2, it says that there are, I guess, it looks like 2 prohibitions from, being able to have this hearing and be deported, and that is certain sexual offenses and crimes of violence punishable for imprisonment 10 years or more, life imprisonment or death, and those are disqualifying factors.
That's correct. That's correct. Those individuals would not be eligible for this particular program. Now, I will tell you that it would appear that some individuals that have certain types of these sentences may otherwise be parole eligible at some point in the future. If it's a armed robbery, let's say, that individual may come up for just a normal parole hearing at some point far into the future, but that individual could still be identified if they are subject to ICE, and then they could essentially be taken similar to the way this process is done.
This is a silly question, and it was probably already explained, and maybe I'm mischaracterizing it if I say it, but I'm going to go ahead and ask it. So it goes through the actual, they would be granted a parole, and then into the custody of ICE, and then deported. I mean, I've read through these amendments really quickly. Then they would be deported, and then there's a provision at the end that says, should they return, that their parole would be parole for the purpose of deportation. Should they return, their parole would be immediately revoked, and they would be remanded to back to the custody.
That's correct.
Okay.
That's correct. And if you think about it, any of these individuals that are identified with a final order of removal or an ICE detainer, which would suggest that removal or deportation is likely, when they finish out whatever sentence that they have outside of this, ICE is going to pick them up at that point anyway.
Sure.
And so this is attempting to address the problem immediately, as well as putting in the safeguards to make sure that all of the appropriate folks know and understand and have input into that as to whether or not this is an individual that we are certain we want to go through this process and that we want to send out. But if a district attorney wants to prosecute that individual and they want them to serve out the entire term in Louisiana, that is completely up to their discretion.
As sitting on, and I'm going to give the mic back because we have another question. But Mr. Chair, real quickly, I want to say I do make a motion that we adopt these amendments at the appropriate time. And I do want to, as a fiduciary, as a state appropriator, I just want, to bring awareness to the fact that, even if it's a third, if it's 100 that end up, qualifying for deportation, and then if it's 300 or whatever, however many that is, the huge cost associated with holding these individuals in custody. They do not qualify for Medicaid, so we're providing, room and board for them, and then all medical coverage. And sitting on finance, that medical coverage. I mean, we have inmates that, hundreds of thousands of dollars a year to provide medical coverage for them. So the cost savings associated with deportation of even a third of what you're speaking of would be tremendous. So, Mr. Chair, that's it.
Okay, thank you, Senator Cloud. Senator Barrow for a question.
Thank you, Mr. Chairman. I have a couple of questions. I'm trying to digest the amendments really quickly. So the process is these are individuals who are currently in custody somewhere here in the state?
That's correct. They have been convicted in state court, and they have a sentence in DOC custody, and they are currently being held either at a DOC facility or at a local facility pursuant to DOC authority.
Can you tell me what type of crimes this would actually entail, since it takes out sex offenses, crimes of violence? What are we talking about? Are we talking about any misdemeanors?
No, because misdemeanors, they would not be serving time in a DOC facility. This would be drug offenses in often cases. This would be
Thefts, burglaries. Property crimes. Anything that's not a crime of violence for which a sentence of 10 or more years is imposed.
Yeah.
So they would go before the 3-member panel committee of the parole, and they would make the decision along with the governor, I think, and the attorney general.
So the way the process would work is that list of names that DOC comes up with that meet the eligibility criteria would be sent to the governor and to the district attorney that prosecuted that particular case. If both of them approve of that individual going through this process, then that individual would be forwarded on.
Okay, so they
to
go
this
through
committee.
the governor first and to the DA, and then they would make the determination in terms of who would go before the panel.
That's correct.
Okay, and once they go before the panel, I know that the fiscal note has not been adjusted, I'm sure, has it? It has not been rerun. So I want to talk a little bit. I know it's going to go before finance, or should go before finance, because what are the expenditures that we may actually incur in terms of actually doing this? I'm seeing a couple of things that should actually cost us.
Far less than the money we're spending to house them. Far less, because if you run the numbers, if you even use the low number of, let's just say, $27 an offender, which we know is a greater number than that when you look at medical care, et cetera, and if you run that per day, per offender, per the life of their sentence, just to have parole hearings is far less than.
So the deportation is going to be on who?
What's
The deportation, the cost of that, who's that going to be on?
Federal government.
The federal government.
On ICE.
So that would not be a cost at all that we would incur?
No.
Okay.
So, and with the 287G agreements, which is what they're commonly referred to between the federal ICE and our state departments that we have entered into, ICE does provide equipment and certain other things that are necessary in order for DOC to collaborate with them, provide this information, and do those types of things. So ICE does provide those types of additional resources, and I think the Chief might be able to speak to that.
Yeah, so basically, under the 287G agreement, the government, HSI will come into your facility and equip 2 or 3 of your booking areas with all the computers, the software, the fingerprint machine, the training, everything at their cost. So this is actually a force multiplier for them. So it's attractive for them to get all these agencies involved, and it's more efficient for us because I don't have to wait for an HSI agent to show up to do these investigation into a suspect's backgrounds or anything of that nature. So it's really a savings to us, the Kenner Police Department, and as Mr. Walters said, once they're put into this program, they'll go into ICE custody. They'll come and take them into custody, which means they're off our rolls and they're on their dime.
Okay, so because I'm familiar and have heard about the enormous costs that it costs to actually do the deportation, and so I did not want there to be any unintended consequences to the state in terms of what that process looked like. Right. Thank you, Mr. Chair.
Thank you, Senator Barrow. The board is clear. We have a motion to adopt amendment set, is it 1920? Yeah, 1927. Is there any objection? There being none, that amendment will be adopted. The board is still clear, so I'm going to read the green cards and then we'll have opposition. Chris Walters, who's testifying blue card on the Executive Council of Governor Landry in support. Chief Keith Conley, Kenner Police, who's before us in support. Zach Daniels, Louisiana District Attorneys Association, support. Christine Russell, District Attorney and District Attorneys Association, in support. Gary Bennett, Louisiana Sheriff's Association, in support. Kevin Cobb, Louisiana Sheriff's Association, in support. Jennifer Bush with the Department of Corrections is here to provide information if requested. And Senator Barrow, you have a question?
I do, Mr. Chairman. I just wanted to question the germaneness of the amendment to the bill. I know that it's been adopted, but as I'm looking, I just want to get a point of order in terms of the germaneness.
Well, I looked at that and I considered it, and they do use the bill. The title of the bill is
Parole.
Parole or diminution of sentence, and this has to do with parole. They use the parole department to do that, and I'm going to rule that it is germane if it's to the extent I can. I guess we could vote if there's an objection to that, but I feel like it's been vetted and it's germane to the bill.
Thank you.
Thank you, Senator Barrow. The board is still clear. We have Bruce Riley with vote is present, would like to speak. And I don't see him in the room. He left. Just in case he's in the hall, going once. Bruce, going twice. Okay. That's all the cards. Pleasure of the committee. Senator Cloud moves to report House Bill 208 with amendments. Is there any objection? There's no objection. There being none, that House Bill 208 will be reported with amendments.
Thank you very much.
House Bill 208 by Representative Villio is enactment Title 15 relative to the release eligibility of incarcerated persons, provide relative to parole eligibility requirements.
Senator Morris.
Thank you, Mr. President. Members, Representative Villio's bill clarifies good time eligibility for offenders who committed an offense before August 2024. No good time for sex offenders and no good time for habitual offenders. It also addresses a split sentences situation. An offender who receives a split sentence required to serve the probationary period imposed upon release from incarceration. And it also, relative to parole eligibility, it changes the time that an offender is to remain free of any major disciplinary offenses from 12 months to 36 months for consistency purposes with Senate Bill 5 in the crime session. It clarifies that penalties for technical violation of the parole apply to offenders released on parole before, on, and after the date is signed into law. And the maximum amount of time that an offender who's in custodial substance abuse treatment can serve for a technical violation is 180 days. And that's generally what the bill does. I do have some questions.
Senator Plessis for a question on the bill.
Hey, Senator, did you say that there was no good time for habitual offenders?
Yes.
Okay, but you could be a habitual offender of nonviolent offenses, right?
I think so, yes.
And
but it means you've committed a whole bunch of crimes.
Right, I understand.
Right,
but they could be like the last one, or a couple of them could be nonviolent.
Yes.
And this would eliminate the opportunity for good time.
That is my understanding.
Okay, thank you.
Thank you.
Senator Jackson Andrews for a question on the bill.
No more questions? Oh.
There's a question on a note. I noticed this bill didn't go to appropriations. It's showing a zero note, but in the explanation, it says that it has a indeterminable amount on the state general fund. And usually those bills that have undeterminable costs to the state budget go to finance.
I think they only go if there's a fiscal note of $100,000 or more.
And we've been receiving, because there's indeterminable amount, we've been receiving those as well. And this seems maybe
Well-
greater than 100,000, but when you look at the explanation, it says indeterminable amount. I printed it out.
I
I'm sure
mean,
someone's
just
brought it
about
to my
every
desk.
fiscal note will say something like that. We probably passed 6 bills in here already today with indeterminable fiscal notes.
And what's the purpose of decreasing good time earned?
I think it's to clean up what was done in the crime session. I think Representative Villio worked with the governor's office and with law enforcement, and she made some amendments, as I understand it, over in the House at the request of some criminal defense people. So she worked with them to get it through the process, but I wasn't over there by the time it came to our committee. All that had been worked out, and
Right. And I'm just concerned because Louisiana prisons are considered grossly unsafe when you look at national reports. If we continuously take away good time, what is the incentive for those inmates to create a safe environment?
well, I don't know. It wasn't safe before we had before we had the criminal justice special session last year, and we've hardly had time to operate under the new system. I mean, parole is eliminated anyway going forward.
So is this retroactive? Because I know we can't pass retroactive.
It's only for prisoners who were convicted prior to the special session last year.
So this would put new requirements on them after their conviction?
I'm sorry, what's that?
This is going to put new calculations regarding good time on them, thank you.
If you committed an offense before August 1st, 2024, there will be no good time for sex offenders and no good time for habitual offenders.
What if they've already, been convicted, tried, they've already taken a plea, and they're under the terms of that plea? Would it go back and change the terms and the calculation of their release date?
No, I think it's prospective only. Well, let's see.
Yeah, I don't know if this is perspective, because even in the fiscal notice says, the proposed law has the effect of requiring offenders who earn good credit toward a reduction in their good time parole supervision dates to return to the custody of the Department of Corrections to complete any time previously earned toward a reduction of their parole supervision. So basically, we may be putting people back in prison that have been released.
No, I don't think it would do that.
As dates to return to custody. If you look at the fiscal notice, saying that it orders them to return to custody while on unsupervised parole, the exact, and maybe that's.
It says any term of unsupervised parole shall be served concurrently with the probationary period, so that they'll go hand in hand. And so they would get credit.
But I'm saying in the reduction of good time. It says proposed law has the effect of requiring offenders who earn good credit toward a reduction in their good time parole supervision dates to return to the custody of the Department of Corrections to complete any time previously earned toward a reduction of their parole supervision as a separate sentence consecutive to any, so you still return. It is a consecutive sentence once you're back. But unless this note is wrong, and I don't have the bill in front of me, but it looks like that's the impact of the bill. And then it says the exact fiscal impact of the Department of Corrections is indeterminable, as it is unknown the number of times that offenders on unsupervised probation, so this is when they committed. Proposed law may result in the indeterminable increase in state general fund expenditures in the Department of Correction to the extent that alien serving sentence for conviction of a sex offense, crime of violence, or crime punishable by death, life imprisonment. It goes on to add aliens who are ineligible for deportation to come back into the system.
Yeah, I mean, the fiscal note is inconsequential in my view. You know, every fiscal note we have has indeterminate. I mean, we look at them all the time in Rev and Fisc and the ones that come through a lot of the committees, and they say an indeterminate amount. You know, if they thought it was consequential, that they would have put some estimates of numbers in there. They didn't. It wasn't referred to finance. And
I agree with that usually, but it says that it's going to cost us $107.60 per offender per day. So although the aggregate of it is, maybe, may not be indeterminable, we know that we're going to pay $107.60 per day per offender.
Right. Well, for sex offenders and habitual offenders.
I mean, regardless of what it is,
Right.
when you look at the note, you're looking at cost.
Right.
I just wanted
I mean, it only applies to habitual offenders and sex offenders.
which an habitual offender can be someone who had purse snatching 3 times,
I don't remember what the exact requirements, but it's pretty hefty. You have to be convicted of a bunch of crimes.
No, you have to only be convicted
Whoever's an habitual offender is not learning their lesson, obviously.
You only have to be convicted of a felony 3 times. And if it was like purse snatching once, purse snatching twice, purse snatching the 3rd time, you're a habitual offender.
Yeah, well, they shouldn't snatch
Heinous
purses.
crime. I agree, but, if you're in between the age of 18 and 22, and that's your thing that you're doing before you mature and realize that it's the wrong way to do, then you become a habitual offender. Even if purse snatching comes without any serious injuries or anything, I always use this as an example so that, at some point we can understand we may need to clean up that habitual offender statute on what's qualifying for habitual offender.
Well, that would be a different bill.
Thank you.
Thank you.
Senator Barrow for a question on the bill. And she waives. Amendments to close on the bill.
Members, this was supported by the DAs, the Sheriff's Association. I think it was probably brought at the request of either the DAs Association or some DAs, and I would ask for you to pass this bill. Thank you.
Senator Morrison finally passes House Bill 208. When the machines are open, all those in favor vote yes. Opposed, no. Secretary, open the machines. Vote your machine, members. Vote your machines. Senator Talbot, yes. Senator Price, no. Madam Secretary, close machine, 26 yeas and 12 nays, and the bill is finally passed. Senator Morris moves to reconsider pass later, must stay without objection.
Next bill is House Bill 208 by Representative Villio, provides relative to release eligibility of incarcerated persons, parole eligibility, automatic earning of good time credits, and there were Senate Jude C amendments adopted to the bill.
Representative Villio.
Thank you, Mr. Acting Speaker. Members, the Senate added some amendments relative to parole and deportation of certain offenders, and I would ask that you concur in the amendments.
Representative Willard has a question.
Thank you, Mr. Pro Tem. Chairwoman Villio, what are these amendments doing, and why do we need them in this bill?
The amendment allows for the creation and duties of a deportation eligibility hearing committee on our parole board, and it allows for certain offenders who are serving time in our prison, at least, nonviolent and under 10 years, to be subject to a parole hearing and be paroled and deported.
So this is dealing with offenders in our jails and prisons who are not legal citizens?
That's correct.
Okay, and then, so what currently happens?
Currently, they serve their time.
So I know, so they serve their time, and when they get out, they're just released?
Unless they have a hold by ICE, then they would serve their time, and then they would be deported.
I'm just trying to understand what this bill is doing that is needed where we have.
This is taking away the expenses of our state of housing an illegal citizen who is in our prison, as long as they're not serving a violent crime, sentence for a violent crime or sentence greater than 10 years. So it allows, at the expense of the federal government, to deport them after a parole hearing.
Okay, all right. Thank you, Chairwoman.
Thank you.
Representative Mandy Landry with a question. Terry Landry, I apologize. Sorry, Rep. Terry.
It's fine.
A lot of Landrys.
Yeah, we got our own caucus, I think.
You do?
Thank you, Acting Speaker. Madam Chair, just a quick question. I'm curious as to why the need to go from 12 months to 36 months.
That was not by amendment. That was in the original bill, Rep. Landry, but I can answer that question for you. That was a bill by Senator McMath in the crime session that passed and was enacted into law, and my bill was just a cleanup bill. That is the law after the crime session, but we had sections of the statute that were not cleaned up just for consistency purposes.
Thank you, Madam Chair.
You're welcome.
Madam Newell, Rep. Newell.
Thank you, Mr. Speaker Pro Tem. Rep. Villio, I'm listening to your comments to Representative Willard and reading this just for clarity. This is not removing an immigrant's, what's the word I'm looking for? It's not taking away any of their processes.
No, in fact, this is giving them due process
processes
rights by having a parole hearing.
A full on trial. But what happens with this amendment is instead of them serving time in one of our institutions, they would be deported to their home country?
They'd be deported to their homeland, correct.
Okay, so to take the expenses off of the citizens of Louisiana. But this is going through a proper process. It's not inadvertently dismissing their cases. It's allowing them to go through the whole trial, and then we deport them to serve out whatever sentence.
The trial is actually over. They're actually serving time in our state prisons now.
So this is people that are here now and have already been sentenced?
That's correct. And this
Okay.
just allows them to go before the parole board and be considered for parole and deportation.
I'm sorry, say that last part again.
It is allowing them to be considered for parole and deportation rather than staying in our prison and serving their full prison term.
Rather than completing their time. So what does this do for someone who goes into, has to go to court after this passes? Once this passes.
This passes, anybody who would go to court and be convicted and sentenced to our prisons that would fall within this criteria could also be considered to go before the parole board.
So we would not hold them at all other than the pre-trial hearing, the time that they're held during that time. We won't hold them any longer than that.
And other than until such time as the parole is granted and they're deported.
Okay, thank you, Rep. Villio, for your explanation. Thank you.
Thank you. The board is clear. Representative Villio moves that to concur in the Senate amendments. All in favor will vote yea. Those opposed will vote nay. Madam Clerk, will you open the machine? Guyman, yea. Amity, yea. Henry, yea. Members, are you through voting? Clerk will close the machine. 83 yeas and 11 nays, and the bill is concurred in. Next bill.